Hi, everyone. How are you? It's Brandon Miller here. Really special presentation today. We're going to be talking about criminal inadmissibility and Canada's immigration laws. Now, if you've ever had any brushes with the law, no matter what they are, you need to be aware of this stuff prior to actually filing any sort of immigration application, because it may or may not actually impact you coming here, but it could actually create some problems if you don't handle it directly. So this is a very specialized area. And what I'm going to do today is I have a guest with me. Her name is Katina Hunter-Sutcliffe. Katina, are you there?
Hi there. How you doing?
Awesome. So Katina's been kind enough to join us today. And so first, let's start off by introducing Katina. So Katina's very specialized. She's a lawyer who specialized in criminal inadmissibility and complicated immigration files. Again, this is her area of specialty, and you know what? Very competent professional. She's based in Toronto, Canada. She's been admitted to the bars of Ontario and New York. So this actually gives her a lot of context when she's looking at different laws from different jurisdictions, which you're going to find out is pretty key. She's lived and worked overseas for many, many years, and she's lived, worked, and studied on 3 continents. 7th generation Canadian. And you know what? I've known Katina both professionally and personally for a number of years, and she's just an all-around awesome person. How was that for an intro, Katina?
Thanks, Brandon.
Awesome.
It's a pleasure to be here today. Thanks for inviting me to come and speak on a topic that, as you know, I'm really passionate about. And you and I somehow seem to always get back to this topic because we both really find it interesting, and it comes up. And it's always better to deal with it at the beginning than after the fact.
Yeah, for sure. For sure. So let's do this. We've got a slide deck here, so we'll run through that and we'll educate some people. And again, this is a recorded session, but you know, again, if people want to reach out later, they can reach out to us through Second Passport, and then we can see how best to help them and channel them over if it's really complicated. So let's get started. So Masterclass, criminal inadmissibility, what you need to know to come stay in Canada. So Katina, I'm just going to handle the slides here. If there's anything, if you just tell me when to go to the next slide and we'll go from there. All right?
All right, next slide.
Perfect. Oh, take it away, Katina.
All right, so sort of taking a step back just to get the big picture to see where it fits in. Any immigration application, there's an eligibility component and an admissibility component. And it's important to understand that they're 2 different things. So eligibility is whether or not you meet sort of the right criteria for the particular type of application you're seeking, be it visitor, study permit, work permit, permanent residence. There'll be criteria for that. But in any foreign national or permanent residents coming and staying in Canada, there's an admissibility piece to it, and it falls separate from the eligibility. And so this is really what we're talking about. So for an applicant coming to Canada, you always have to prove, the onus is always on the applicant, on the foreign national, to show that you meet the eligibility criteria for the particular class and program. And there's also, it's almost like it's your responsibility to prove that you're not inadmissible. So it's not like you're assumed that, you're the fact that you don't have a criminal record, or you do or you don't, none of that is assumed. It's your responsibility to present it. And so the other piece with that is that, it's an ongoing, there's a timeline aspect to that. So the admissibility piece is going to come up when you're making your application and when you're submitting it if you're overseas. It's also, and even once you get an approval and like a check mark that there's not an admissibility hasn't been flagged or triggered, when you're actually crossing a border, a port of entry, and you're coming into Canada, if you get called in to speak to immigration, that's also a second opportunity where admissibility may rear its head again. So you just need to be aware of that. And then if you're in Canada and something happens, either you're arrested or you have some sort of issue or something from your past, all of a sudden that wasn't on the table comes up, it can be revisited. So it's just important to understand that admissibility is an ongoing assessment, whereas eligibility is you're either eligible or you're not eligible. So with that being said, we'll just move to the second slide.
I just want to say something really quick, just to sum up a little bit there, because one of the things that I always think about when I hear about this is it's very strange, especially somebody coming from, you know, a democratic rule of law based society. It's really strange for people when, you know, we've got this maxim, you're innocent till proven guilty. But really in the context of immigration law, just zeroing in on what you said, it's more guilty till proven innocent. Would you agree with that?
Yeah, well, because the onus is it's almost like there's a reverse onus.
Right.
Absolutely. Yeah, and then the other note that I wanted to make is, so, you know, eligibility is determined up front, and admissibility is usually, it's decided from a immigration officer's processing point of view. It's decided I look at it as it's an 11th hour decision. They might go through the whole application, the whole process, determine you eligible, and then all of a sudden they're going to turn to admissibility issues, especially in the context of a permanent resident application. And so, yeah, it's a little counterintuitive, because you would think that if you're eligible, you meet all the criteria, that's all being assessed, then why are we now kind of clawing back a little bit before, like a step back before we take 2 steps forward to approval? So yeah, I see it the same way.
Yeah. All right, let's move on there.
So over the still overview, there's 8 admissibility clearances. I'm just kind of going through these as a checklist so that you sort of see where today's topic, which is criminal, fits in. These are set out in there's one major immigration statute in Canada, and it's set out all nice and tidy in one section. And so what Canada immigration is looking for, big picture, is they're looking to see if there are any security concerns in your background, if there are like human rights violations, if there's potentially a health or a medical inadmissibility. And that sort of ties in with the fact that generally when you come here as a worker or permanent resident, because of Canada's social structure and because health we've got a public health system, there's an idea that there's a benchmark there, and that it can trigger an inadmissibility if under certain circumstances, which would be, I think, the topic of another discussion.
we're gonna do medical inadmissibility, and we'll dive into excessive demand and all that other stuff.
It's its own area, and then there's financial. Then there's compliance. Compliance is really just about whether or not you've complied with previous immigration regime rules and frameworks in other countries. The protection cessation is specific to refugees. If your refugee protection has ceased, it may trigger an admissibility issue. And family members. So when you're looking at, even though applications generally are limited to a particular person, if there's accompanying or unaccompanying family members, there are circumstances, depending on the class of the program, whether or not there's going to be a collateral effect of inadmissibility for the principal based on a family member's criminal history. And then we get to criminal, which is the topic that we're here to talk about today. Criminal comes right out, it's split up by the statute into 3 categories. We've got organized criminality, which is its own category. And then we've got, and we're not really going to touch on that too much today, because if you've got a concern or if you know something, organized criminality needs to be dealt with head on. So if that's a situation, you're going to want to have that assessed.
If you've been in the mob, that's maybe an indicator we might want to have another conversation.
Yeah, so putting aside organized criminality, what we have is criminality, which is really split into serious criminality and general criminality. The general is in brackets on the slide because we don't actually call it general criminality, we just call it criminality. But so that's what we're going to kind of focus on today in our discussion.
Can I just dive in there, because I like
sure.
a few things here and there, as you know me so well. Just to put it in context, so first off, we keep referring to the act, so it's the Immigration Refugee Protection Act, and generally where these fall, it's generally in the 30s, right? I'm not going to get into the exact different things because that's just too much, but I call them the naughty clauses. So if you've been naughty or something, you're going to find all of those things in the 30s. Okay. The other thing, actually into the 40s too, if you want to get into misrepresentation, but again, another day. The reason this is important, I just want to give you some context why the government actually looks at these and they see them as something that they want to screen for. So think of it this way. Sometimes you'll hear people pop up on the news, for instance, and they might have been a war criminal in World War II, or they might be accused of, human rights abuses overseas or something like that. You can imagine that if somebody is now a permanent resident or even a citizen, you can imagine what that's going to look like when, you're going to take away their permanent residency or their citizenship, for instance. That's a process. And there's a number of different cases over the years. So the government wants to make sure up front that they're screening. And I know those are more, those are some more headline grabbing examples. But the government wants to screen these things up front. And that's why everything that Katina has mentioned here with admissibility is very topical. But again, to stay focused, we're only on criminal admissibility days. So can I go to the next slide?
Yeah, sure. To your point, Brandon, I always look at it as really what the immigration officer's job is to make sure that anybody coming in is not going to pose a threat to the safety or the security of those who are in Canada. And that's just to make sure that we are maintaining an environment and a country that abides by the rule of law. So it's for us all.
And the preamble of the act actually outlines that as one of the goals of the act, to protect Canadian citizens and people inside of Canada. So awesome. Yeah, no, that's exactly why they're there. Okay, let's move on.
So the next slide, what you'll see is, so from a practically speaking, from the point of view, where does this come up for you, right? Like where does in the like the nitty gritty, where do you start to see this? And where you start to see it in the application process is right there in the immigration forms and the paperwork. And, depending on, and the question will be asked differently if you're looking at either a temporary application or a permanent application. But so the first, so I've taken right off of one of the immigration forms, the way you see it and where it's asked. And so you'll see it, you'll be asked very straightforward and simply, have you ever committed, been arrested, or being charged with or convicted of any criminal offense in any country or territory? And you are going to either hit no or yes. And you're going to sign the form, which means that whatever you say, it's almost as if you're swearing it under oath. Like you're going to be taken at your word, and it's going to become part of your immigration file with the IRCC. So it's really important that you understand what their question is asking, because you don't want to get it wrong. We'll get into why a little bit later. So let's say you hit no, it's fine, you sign it, it's all good. On some applications, you'll also be required to supplement with supporting documents. Sometimes you're asked for police clearances from countries you've lived in, or sometimes that will come later. In the instance that you're asked yes there, then usually at the basic level, you're asked to provide details. And so the thing is you don't ever want to be in the situation where you're providing details where you don't understand what they're asking, what the implications are, where it's going to go, what you may need to support it. So that's why I commend you for taking the time to listen to us talk today on this topic, so that you'll sort of be able to understand the big picture from the beginning to the end of the process, so that when you are at this initial step, you understand what the scope is and how to efficiently and correctly address it.
You know, so I would venture to say, and nor whoever's watching this, if you're clicking yes, you do not want to submit that application by yourself. Okay, would you agree with that, Katina?
The way I would put it is that if you're clicking yes, you better really understand what the implications are and be fairly confident that you're not going to trigger any flags. And so you're probably going to, at the very least, want to do a consult to just have it reviewed. So a professional who knows exactly how these things get sidetracked can take a look at it and say, oh, that's of a concern or that's not a concern. So
yeah, that's a better way of putting it. So let's revise that. So if you're clicking yes, do not submit that form without getting some sort of opinion on exactly what that means. Because quite frankly, the way this works, and I've seen this in past where people will go and they're self-representing an application, and then they'll put something in and then it will trigger a request. Okay. And for instance, in the Philippines, right, you can get an NBI check and it'll say no derogatory record or no record on file. There's a difference there because something actually is on the file. And then the embassy will come back and they'll ask for more clarification. And this is the point, and the saying that comes up from me is I heard it contextualized by a lady who was an immigration officer at the embassies for a number of years and used to do these interviews. Basically, she used the statement, give them enough rope and they'll hang themselves. When the immigration department is coming back and asking you for clarifications, a lot of people are like, oh, it's okay. And I'll just give them the information that they're asking because I want to be cooperative. No, they're dotting their I's and crossing their T's so that, that then you're going to get you're potentially going to get a very nasty letter back. That's why you need to understand the implications prior to doing your application, thinking strategically up front, and then submitting.
And James, this is where Brandon and I get into some really interesting discussions, because what we invariably see as professionals in practice is that, people from their context and where they're coming from, they don't think that it was a big deal or that there was a criminal element to it necessarily, because in their environment or in their lives, it wasn't, they didn't spend 2 or 3 years in jail. They don't self-identify as criminals. They're not branded with that. They've had no issues with getting employment anywhere or whatnot. But what happens is because we're professionals in practice, what we see is we see it down the line when something happens, and it's a lot easier to get it right out of the starting gate than to try and fix it. Because if you're in a situation where you're trying to fix it, especially that's what Brandon and I we've conferred on situations before where we see so clearly why the applicant took the point of view that they did, but then down the line you've got to undo that or fix it, and it's then your need for professional representation and the extent of it and the cost of it is going to be much higher than it would have had you just known to address it somehow differently from the onset.
And it might be too late in some circumstances. You might have actually done too much damage to yourself. And the other issue is that, it could be as simple as timing. You might be deemed rehabilitated, and if you just wait on filing that application in a month, for instance.
And you won't know that if you haven't reverse engineered the process. So we're gonna touch on that a little bit.
Dive into it.
Yeah.
I'll keep going here.
So
Okay.
then again, in the application forms, we're still looking at the application forms where you've got this disclosure requirement and you want to make sure you get it right. These are the questions that break down to where they're tapping into the family members, because again, it's not necessarily intuitive. I wouldn't think it's intuitive to you that your application is going to, that you're going to be determined, you're going to be assessed on somebody else's behavior and his criminal history, because in the criminal justice context, that's not the case, obviously. So sometimes, so again, in those situations, so when you look at the way it's asked in this, and this is again taken right off of the form from a permanent residence form, it asks, have you been convicted of a crime or offense in Canada for which a pardon has not been granted under the Criminal Records Act? So all of a sudden it introduces this concept of pardon. You may or may not be familiar with it. And then it also breaks it down. Are you currently charged with? And notice how all of a sudden, from the previous question where they sort of just asked you generally one question, yes, no, tick box. Now we're digging down. Now they're asking whether or not you've been charged. Well, a charge is no conviction, or if you're currently on trial for, or if you were party to a crime or an offense. You can see it's broadening out. And now they're looking at any other country. So then you've got to sit there and think, well, wait a minute. Was the situation you're in, does it fall under one of those categories? And by reading it, you don't necessarily know whether or not that's the case. And then if we switch to the next slide, because the questions continue, what we'll see is it asks, have you ever been refused admission to or ordered to leave Canada? So now all of a sudden, you know right now that you're in there's an admissibility. This is essentially an admissibility questionnaire. And then right down at, and then it says, have you been detained, incarcerated, or put in jail? So, so this just lets you know that right there at the top, it says, have you, the principal applicant, or any of your family members listed in your application? So you might think that if you've, because what does listed in your application mean? Sometimes what we've seen in practice is that people don't think that if you've got a family member that's not accompanying you or has no intention to relocate to Canada with you, well, then they're not really part of your application. That's not necessarily the situation. Because with any immigration application, it's not just that first application. There's generally additional forms where you have to list your family members and where they live and what their marital status is. This is where it captures, well, what's their criminal history? Have they ever been incarcerated? Have they ever been put in jail?
Yeah. So again, you can see how when they drill down on these questions, this is more like going back to my analogy of like give them the rope. This is giving you more rope, because what's happening is, and you can't lie. We all know, like, we were taught at a very young age, don't lie. But on an immigration application, if you check no and you sign that form, that's some very serious stuff. It's the same thing as basically sitting in a court of law, putting your hand up and swearing on whatever book you want to done, but you've done it in writing. So sorry. Yeah, exactly. Right. So the other thing to put in there too, is that family members, now it's funny, Katina, because I just had this question within the last 2 days and they were asking about a brother. And I said, nah, I wouldn't worry too much about the brother because the brother's not going to be part of an immigration application. It's not really going to affect you going forward. However, parents, children, specifically children and spouses, because again, going with the Immigration Act, you look at the preamble there, and one of the goals of the act is to keep families together and reunite families, right? I know, yep. the hands, right? So, yep. If they admit you and you have no record, but the family members haven't been screened and they have a record, we're kind of not.
There's a potential conflict between the objectives, the Canadian objectives.
Yeah. Yeah.
And of course, we hope to think we're running a system that that makes sure that we don't find ourselves in those situations.
Exactly. Do you want to go to the next slide, Katina?
Yeah, so right there we were talking about what we see on paper applications. And the nice thing there is you know what the questions are and you only have a limited space to answer. But then let's jump now to what happens. Remember, we had mentioned that it's not just on the admissibility is always also open game to be assessed on entry into Canada, so at the port of entry. And that's when you actually have the what may happen is an officer may sit there and look at you and they're not reading questions off a piece of paper and asking you to tick it. They're engaging you in a conversation. And to your point, Brandon, that there's, give somebody give somebody the opportunity and they'll sink themselves. All of a sudden, the questions can be very broad. So I just sort of kind of listed here the things that, just to show you the things that you may be asked, right? You may be asked specifically, hey, has your partner ever been charged with fraud or shoplifting? Did the crime charged involve physical harm or violence? So you may be sitting there going, why are they asking me this question? They have their reasons because they're trying to make a determination. The other thing you've got to understand is in the last few years, there have been agreements reached between governments that share information, particularly the United States and Canada. And so you can assume that the border guards at the border on a Canadian-US border, they're going to be able to pull up the NCIC records to see whether or not you have an arrest or you have a conviction. And so they may actually be like, they may have something in the back of their mind. They may see something and go, wait a minute. Why hasn't this person mentioned this? Are they trying to slip through? Do they not, they're not thinking, do they not understand it? They're thinking, wait a minute, I asked a question and I have something that's indicating to me that there may be a concern. And why isn't this why is this information not forthcoming? The other thing is you'll find you may get into a discussion. They may want to know, do you have a pardon? Or so what you have to understand is because you may have the visa that you think you need, you may have the TRV, you may have the counterfoil in your passport, you may be there, you may be ready to get the work permit printed, because the admissibility check has already been done in the application phase of the thing. You've sent in police clearance certificates or whatnot. You're like, well, why am I being asked these? It's because this is just another opportunity for the admissibility issue to be checked, to make sure again that whoever is being admitted to Canada is not a threat to the safety and security of those already in Canada.
Yeah. It's important to understand that a lot of times people, they see customs or the border officer is just, I'm going to get my passport. I just want to get to my hotel or do whatever or get landed. But the border officer in Canada, called the CBSA, the Canadian Border Services, they play a very key role. They're the last line of defense and the last check. And no more than a couple days ago, I was having a conversation with somebody, and we got the passport request, which basically means they're putting a sticker in the passport, and that they can take that and then they can go. And it's like, basically it says, give us your sticker. And I was explaining to her, I said, this is they can put the sticker in, and a lot of people think that once they get that visa in their passport, they're fine. Now, she was coming under a student visa, and I said, no. Your student visa is actually issued at the border, and there's going to be checks where the officer is going to go. So you might even get something in your online portal that says you're approved. You're not approved. You're not approved until they get to the border. And there's instances where the border officer will ask questions and they'll say, you know what, this isn't right. Or, they might find that you had a DUI or something as an example, and that's a favorite because a lot of people don't think of that as criminal from different places. They might ask that question, and guess what? There goes your permit, there goes your PR right at the border. And in some cases, and I've seen it where people have called me up frantically. I always tell the story about, it's 4 o'clock in the afternoon and a friend of mine calls me up frantic because his friend landed, and basically the happiest day of their life was their permanent residency, and it got shifted away. The border officer seized their passport and said, you need to be back here in a month, and let them go. But they kept their passport and did that. So again, just because you have an approval, it is not approved until you get through there. And frankly, we'll get into that in terms of what citizenship means and as a PR. But these questions, if the officer has any little like spidey sense in the back there, they can pull up your record. The computer systems are more interlinked, and they can also fingerprint you at the border and get into all of the Interpol records and everything. If they want to do that, they will keep you there, and they have the power to do this. They do not have to admit you. And if there's any concerns, they can actually not allow you to go in and send you right back to where once you come. So
yeah, and to your impaired driving is a very good example of where we see these sorts of things just roll out of control, because in some states and in some countries, impaired driving is a traffic offense. Yeah. It's not actually doesn't even fall under a criminal offense. So it makes sense that somebody who has had that experience or that incident, they don't think when they're looking at the form to check criminal conviction, especially for when that first type question, right, for the temporary resident. But what happens is because they don't ask you on the form, hey, have you ever been pulled over and stopped from driving after having a few drinks? But
that'd be a good question.
Right. Well, the thing is but that's why you see that a CBSA officer at the border has a little bit more time, and maybe you've gotten off your plane, or maybe someone's gone off their plane and they're stumbling around.
Yeah.
The guard is sitting here going, oh, this might be a drinker. I wonder if he's got any issues and whatever. And then he asks, hey, have you ever been driving? Hey, I see that, have you get a conversations can go sideways very quickly. And that's when they ask, hey, have you ever been pulled over? And then all of a sudden the conversation becomes, oh yeah, but nothing happened. I paid a fine. Then all of a sudden, then all of a sudden you're not just dealing with the question of what the implication of that is in terms of criminal inadmissibility. Then it also all of a sudden has raised a question: did you misrepresent on your form, because to have gone to the point that you got to, that sort of implies or infers that there was a misrepresentation, which is another ground in and of itself of inadmissibility. And if you're found, if it's determined that you had misrepresented, and it doesn't matter here if you intended to, or there was malfeasance, or you were just ignorant of the law or whatever, if you misrepresented and you're hit with a misrepresentation, you then possibly have a 1, a 3, a 5-year ban from entering Canada. So that's why it's really important to understand what the scope of criminal inadmissibility actually captured, and a little bit of how it works when you're looking at laws and incidents in other countries to Canada, because we're operating in different jurisdictions with different ideas of what criminality is. And I think this is why Brandon and I geek out on this area, because it really is. It's so fascinating when you sit there and you look at what's considered an offense in one country and not an offense in another country, and then you start. And that, Canada is a multicultural country. It's the beauty of the fabric of our society. And so, but sort of immigration is one of the playing fields where these may come. They come head to toe on, so they need to be assessed and discussed.
Yeah, awesome. Let's move on.
Okay, so that brings us to sort of informed disclosure. The 3 big takeaways here, is the way I see it, is it's really important to understand that the onus is on you, the applicant, to prove that you're admissible, and that omission is no defense. and that, to the point that we just talked about, you've got to be wary of misrepresentation. You don't want to get it wrong. You don't want to have to try and fix it later. You want to get it right from the get-go. And then the last point there is, and I think Brandon had touched on this when you first started, we see all colors and all types and all people from, with lots of different backgrounds. And sometimes, and our Canadian criminal justice system, which also plays into and feeds into our immigration principles, is we believe that, you should not be branded for a lifetime on something you've done necessarily in the past. We have this concept of rehabilitation, and we're going to come to it in a little bit in the context of what we're talking about today. So the thing is, you know what? Maybe you did overstay in a country. Maybe you did violate some rules. Maybe you do have an impaired driving charge. You know what the important thing here is it's not about hiding it. It's not about it being a cross mark and closing the door. What's important is you have to own your past, because that's the first step of showing that you're able to step into a place where you are not a threat to the safety and security of those who are in Canada. And that ties in with making sure that you understand what the immigration rules are and what the remedies are.
Yeah.
Because we've got a whole system that's built into this, because we understand that life is a continuum.
It's funny. There's so much stuff that you just said there that I just want to comment on. So a few things. First off, misrepresentation, that's capital crimes. And it's funny because I wrote my book here, and the one thing I tried to make this very user-friendly to everybody, but the one thing that I quoted directly out of the act is misrepresentation. That's the one thing in the book that I said, because it's actually so key and it can sink you. The other thing is too, that I always tell people, and I contextualize it, is that you really have to own your past, and you have to, confess your sins, so to speak, right? Because if you get caught lying and that misrepresentation, you're done. Well, not done, but you're pretty much done. And your credibility goes, and then all the other stuff. And it's like, if you're lying about this or whatever, inadvertently or not, right? And that's the thing where people don't really understand that they have to be very careful with that. So again,
the fix gets much more complicated and much more expensive.
Exactly. And you have to confess it and let them know, but you have to do it in a managed way. I think that's what's important, really.
Yeah.
Cool.
And so now with all of that being said, what we're going to do is we're now going to kind of look at a little bit more in detail criminal and admissibility. Yes, it's in the 30s.
The naughty 30s, Katina.
And what you see right there is serious criminality and general criminality. It's actually under the same provision, interestingly enough. But then you start to see differences. And this is why there's a lot of information right here. So let me just kind of try and break it down a little bit. And so what you've got to understand is that there will be the effect of what it is that is in your past, or that is maybe currently going on, is going to affect a foreign national differently from a permanent resident. So a permanent resident, if you will, has more rights than a foreign national. So a foreign national. So let's look at. I'm going to look at the bottom one first, general criminality. It only applies to foreign nationals. And what you're looking at is whether or not there's a Canadian conviction or a foreign conviction. And you just need one. And so all of a sudden, and this wording is taken right out of the Act. This is how it's explained. And again, I wouldn't anticipate a lay person in Canada to know what the term indictable offense means or summary conviction. but it's important that you understand what that is, because you need to be able to determine and categorize whether or not what it is that had occurred falls into the category. So I'm going to break this down in a little bit more detail, but I'm just going to go. So general criminality applies to foreign nationals. And there are three categories. You're looking at Canadian convictions. You're looking at foreign convictions. You're also looking at whether or not you committed an act outside to Canada. So there's no conviction there. It encapsulates the actual commission of an act. So again, that's important to understand what that means, because it's not intuitive. And then there's actually, under general criminality, a fourth category, which is committing an act on entering Canada. And that kind of touches on custom violations, or like, it didn't have to have happened in the past. If you're in the process of doing something, then you need to understand that they have the ability right then and there to stop your entry and to turn you around, and even possibly initiate arrests. But for serious criminality,
can we just pause there for a second, Tina? Because there's something you said, and this is one of the biggest things that I see a lot of, and I know you will too. People, you got to really wrap your head about that. The immigration officer has a lot of discretion. And if they think that you've committed an act, you might be like, yeah, I went to court. I was found not guilty. No. If they think you committed the act and there's reasonable information to see that, it's not guilty till proven innocent. Innocent till proven guilty. It's guilty till proven innocent.
And because that comes back to the fact that it's the onus is on you,
right,
to establish that you are not. So we have clients, and we advise them to travel with their court records, with their documents that show that that there've been discharges, that they've received pardons, and more. Because the thing is the reality is that can make the difference between whether or not you're going to get through the border or not through the border.
Yeah. The other thing, do we dive into indictable summary and even?
Yeah, it's the next slide. Is why I don't want to. Yeah. We'll get into there in a minute. So the only other concept that I want to think in the context. So serious criminality will apply to permanent residents and foreign nationals, which means that permanent residents, whether or not they're actually at the moment living in Canada or living abroad, they are they can have their permanent residency taken away for serious criminality, not for general criminality, but for serious criminality. And that's why, again, what you're looking at is there's got to be a Canadian conviction that's punishable by 10 or more years in jail. It doesn't mean that, let's say you have an impaired driving offense, right? You're a permanent resident, gets pulled over, let's say in Canada, just to make it, match with this, pulled over, first offense, it's prosecuted, and you're not even given any jail time. You pay a fine, you lose your license, a couple of things happen, or you end up spending 8 months in jail, right? All of a sudden, so you're nowhere near the 10-year mark. But because the offense itself, the way it's written up, it is punishable. It falls into the category. It's the objective categorization of that offense, not that it has to be, trigger 10 or more years in jail. That all of a sudden you're looking at losing your status in Canada if the result of that you've been sentenced to 6 more months. So there are some pretty serious implications there.
And then with evaporates.
Yeah, and then with foreign convictions, what happens is there's, so, and I've underlined it here, there's an equating. So again, different jurisdictions have different systems. They describe their offenses differently. They may have different criteria to arrive at a conviction. What happens if you're dealing with a foreign conviction is then becomes, it's an exercise of equating it to what a Canadian matched equivalency would be. And so that's why this area starts to get, when you've got the ability to deny somebody entry or pull away permanent residency, you got to make sure that you understand the details here.
Yeah.
So with that being said, we'll switch to the next slide, which kind of talks about what you were just asking about. So we always start, a good place to start is to understand. And again, as people who are interested in coming here, we don't, I would never assume that you would understand that the criminal justice system in Canada has 3 classes of offenses. I don't know how many Canadians who've never had any brushes with the law would maybe even know this. So Canada breaks it down into 3 different classes of offenses. We've got something called an indictable offense. It's just it's the term. And so we call them pure indictables. And so an example of that would be murder, right? If you kill somebody. And then we've got a second class of offense. It's called a summary conviction offense. An example of this is a public disturbance, or soliciting prostitution, or vagrancy. It's somewhat, I don't want to say it's minor, but it's essentially it's not murder. So they sort of show you the 2 extremes, right? So that's the way I look at it. You got summary conviction on one end, going all the way up to indictable. But what Canada has done is they also have a hybrid offense. And so what happens with the hybrid offense is it's actually written up in the books, the law books, that, hey, if you commit an assault, it can either be prosecuted as an indictable offense or a summary conviction, and that's usually at the election or the choice of the prosecutor, the Crown. So you're charged under a section, and, let's say in relative terms it was minor, right? They'll proceed as if it was a summary conviction, but it's not a summary conviction offense. It's a hybrid offense. And the reason why that is so important to understand is that for immigration purposes, all hybrid offenses are deemed to be indictable. So it's like, if you think about it, if you do something that in Canada you would be charged, like the sentence and the conviction would fall into the summary conviction category. From an immigration point of view, it's as if you had done the worst thing possible in that category of offense. And more than 90% of the offenses in the Canadian Criminal Code are hybrid. There's very few, there's like a laundry list of summary conviction, which means essentially you're looking at, from an immigration point of view, So the other thing that I put up here is for those of you who are coming from the United States, or for the rest of us who, we watch,
watch a lot of TV,
American television or movies. This idea of felonies and misdemeanors that seems to be language that people understand a little bit more. So like a felony murder charge, or you'll see like when I'm speaking, sometimes Americans will say, "Oh, it's just a misdemeanor conviction." It's almost like it's so a lot of the times you may find, you could loosely say that indictable is kind of felony and misdemeanor is summary conviction. But what the U.S. doesn't have in sort of the same type of framework way is the hybrid implication with the deeming provision in the immigration context, which essentially means that we have our 3-class system under the criminal code has become essentially a 2-class system, sort of akin to the American criminal justice system.
Can I ask a question just out of curiosity? Because I don't know this actually, and I know you work with this a lot. The hybrid system, are we kind of very unique in that, or is that more of a Commonwealth thing, or?
It's more of a Commonwealth thing because England has it and Australia has it, and so it's a Commonwealth thing.
I've seen it in some common law countries, but outside of the Commonwealth,
nowhere else. But see, the thing is, from a Canadian immigration point of view, when we're looking at doing an equating of the offense,
right?
What we do is it doesn't, like, it doesn't really matter if in the foreign country they've equated it as a misdemeanor or whatever else it may be called in that foreign jurisdiction. What's important is when you sit there and you match it to how Canada is. Yeah. Canada is the standard because it's Canadian immigration, and so what really happens there is you're looking at how it equates in Canada, and that's why I love this area, because it becomes really interesting, because you start to see how, in different systems and in different countries, you sort of see how criminal justice and social justice, how the mechanisms work to balance themselves, and then you see where they're different from Canada. And so then it becomes, if you do end up, like one that Brandon and I have spoken about is vehicular manslaughter, right? So when you in a traffic accident and somebody dies, right? So what you'll find is in some countries, like the Philippines, for instance, you don't necessarily even need to be convicted. Just the act occurs, and then all of a sudden, that because the act occurred with or without a conviction, it equates to a section of our criminal code here, but under identical circumstances in Canada, you would never have gotten a conviction because of our burdens of proof and defense and contributing factors and whatnot. But in the context of assessing criminal inadmissibility, the immigration officer is not retrying the case. Their job is not to say, would he have been convicted in Canada in that offense? It's not what the assessment is. The assessment is did the commission of that, does that act equate to something in Canada? Right? It's so much more general, and it doesn't. You don't actually benefit from all of the assurances that we have in our justice system. So that's why it's really important to understand when you answer those questions. Sometimes they need to be explained and presented so that the cultural lens of where it's coming from can assist with putting it into context so that the immigration officer can make a decision that he otherwise might not make in your favor. He or she.
He or she, I was just going to say. Okay, let's move on.
And so again, the intersection of criminal and immigration law is that immigration law in Canada will deem all hybrid convictions as if indictable. So let's talk about the impaired driving again, or assault causing harm, or fraud under 5,000. Actually, we don't even need to go to over 5K. All three of those offenses are categorized as a hybrid offense, so they're all going to be indictable, which means that if you get 6 months more jail on any of those in Canada and you're a permanent resident, you're now in a serious criminality category. Or if you're a foreign national, it's a trigger for inadmissibility, and you're not coming to Canada. And then what else do I have? Oh, and the other thing is so we've been talking today sort of in the context of the Canadian Criminal Code and criminal inadmissibility being, like crimes. But when you actually read the IRPA, it's actually a little broader than that. It's any act of parliament, which means it has to be a federal offense, right? So again, that requires a certain understanding of the fact that our system here, we've got our government, we've got a federal government and then provincial governments, and they intersect with responsibilities and powers in immigration and to a certain extent criminal justice. But what I think of when I look at these, when you see it, where it starts to become a live issue in an immigration admissibility context is federal statutes on tax, federal statutes on narcotics or customs. So I just make that note again, so that when you're sitting there and you're looking at, doing your own preliminary, is this a concern? Is this not a concern? You need to look at a little bit outside of just the Criminal Code of Canada.
Awesome. I'm going to hit the next slide there.
And then that just brings us sort of to, this is sort of where we're coming to this point. So really, at the end of the day, you want to make sure that you're assessing the facts. You're trying to get a handle on what the scope of a potential inadmissibility is going to be, and timelines here. So timelines there sort of, it refers to, the assessment of the inadmissibility, but also timeline is also important, because you need to understand when timelines in terms of the actual event you may be concerned about, right? Because what we have is there are remedies that are built, or solutions built into the system. So if you received a pardon, in Canada we call pardon what generally understood as a pardon, we call it a record suspension. Some countries call it expungement. That's like when they take the conviction and it's eliminated or taken off of the books, right? And so we have certain provisions that if you've gotten a foreign expungement or a pardon, if it equates to something in Canada, then that may remove the inadmissibility, right? And then the other important thing to understand with that is sometimes, like in the United Kingdom, for instance, there are certain types of offenses like impaired driving and narcotics that they get spent. The if they were relatively minor, they'll, by operation of law, over a period of time, they'll be taken off the books. They'll cease to exist. So if that's the situation, then potentially there's no inadmissibility. So you're going to want to know that. So, and then on top of that, we also have this concept of rehabilitation. Rehabilitation means that you're no longer at risk of engaging in that behavior such that your presence would put the safety and security of Canadians at risk, right? So we have a deeming provision in the Immigration Act that sort of offsets to a certain extent the harshness of that first deeming provision we talked about that deemed, every hybrid indictable. And so let's put it this way: if you've just got, and so what happens here is if you've only got a single conviction and 10 years has passed, then there's a good possibility that all of a sudden you're deemed rehabilitated and you're not going to be determined inadmissible. But then again, we have to remember that because the onus is on you to show that, you don't have to show them the law that you're deemed. You have to show them that you haven't committed any other offenses, that you actually served the full terms, paid the applicable fines and stuff. If you want to avail yourself with that remedy, you still have to, you're going to want to understand what it is so that you can articulate it and make sure that you've got supporting documents available if it's asked for, or if it's needed, so that you can meet your burden. And then if you don't fall under any of that, you can actually apply. If 5 years has passed from when you've completed the terms of your sentence, and that again, this ties into what we talked about earlier, that there's this idea that you shouldn't be tarred for life with something that may have happened in a misspent youth or whatnot.
We've seen a few of those, Katina?
Yeah, yes. There's an application process, and so if you're looking at, if this is going to be an issue, and this is what Brandon said at the beginning, it doesn't mean that you stop at go and you can't go anywhere else. It may be a process of applying for rehabilitation either in advance or concurrently with your other applications, such that you're basically saying, look, I've been, this is who I am. This is what my life is. This is what I am, bringing to Canada. And there's a whole application process to that. And so that needs to be looked at and done done well and properly. And then if that's not available to you, then we do also have, because now you have to think about, I look at it this way. You look at the rock stars, they're never going to fall under a deeming. They're never going to be able to apply for rehabilitation because they may or may, because of the circumstances of their inadmissibility. But hey, they'd like to, on their world tour, stop in Toronto, Vancouver, North Bay, wherever, and bring, a few $1 million into the local economy and bring the joy of their music to the audience. Well, we have particular applications that may enable them to come and do that. So the TRP acronym there is for a temporary resident permit. It's an application. It can be issued for a one-time, or it's just another mechanism to overcome an inadmissibility. It doesn't take the inadmissibility away. It gives you a pass, a visit pass. Then there's also minister exemptions and stuff. So with all of that being said, I think that really the big picture you should think is that, you don't, this is not intuitive. It's and there's layers. And that really the key is to understand that you need to ask the questions, and that there's no such thing as a stupid question in this situation, because even like, that's why it takes it's a specialty, it's a subspecialty. And sometimes there's an easier fix, and sometimes it doesn't get complicated, but you're going to want to make sure that you understand what the playing field is, you understand what your issues and your concerns are, so that you can make sure that you're navigating the process the best way possible.
Wow. I think that's our last slide, but
yeah,
because remedies and next steps. You know what? I want to say something. I love the Rockstar provision, because I usually use the sports. I think of Mike Tyson or something, right? Like he's never coming, but if he came up for some signing, there's a lot of people that would love to see him box. And mind you, he's retired now. But, think about that. Or I think of, when you said that, I was thinking about Keith Richards, right? Like he got nabbed here with, I think it was heroin, wasn't it? Back like 30 years ago. They made him play a benefit concert for drug rehabilitation. So again, the law is the law, but there is discretion that's given for certain people and certain things, and maybe somebody who didn't know. A TRP might be available to somebody who's coming up, just as a real world example, somebody who's coming up for a business meeting, right, has no idea about oh my God, the DUI like that, and they have to come in and do that. The officer at the border has the discretion to say, all right, go over there, pay the $200. I'll give you this thing, this TRP, this thing, and you can come into Canada. The officer can't say, that's a really sad story. I feel really bad for you. You seem like a good person. I'm just going to let you skirt, because that's the law. The officer. Yeah,
they don't have discretion to do that, but they may have discretion to on a separate assessment.
Right. And issue the TRP right then and there at the border if they need to. Anyways, listen, Katina, man, this has been fantastic. Thank you so much. Thank you so much.
It's been a pleasure. Thank you for your time and your attention. And if you have any concerns at all, please, don't do it by yourself. Just reach out.
Even if you just need to figure out what's going on in advance, that's all you need to do. But if there's any question that you have, any concerns about anything in this area at all, don't file that application until you get an assessment, because you got to think strategic. Don't think here and here, because once you start going down that pathway, you can't come back from it, because you filed it, you're in the system, and that's it.
It's part of your history.
It's part of your history. And quite frankly, we have these things called UCI numbers, and the UCI number is a unique client identifier. Once you put that in there, you're in the immigration system, and they don't retire those UCI numbers until 9 years after the last interaction you've had with the department. So you're going to be there for a long time. the other thing is too, is that, you know, you have to think strategy, you have to understand, and you have to make sure you plan in advance, and then you can actually manage things. And that's what a professional opinion might do for you. Anyways, let's leave it at that. Katina, thank you so much. And guys, take care. Hope everyone's doing well, and hope you learned something about criminal inadmissibility today. So take care, guys.